everyone, and welcome to our first annual Constitution Day address. My name is Michael Gonzalez. I'm the Executive Director for the Institute of American Constitutional Thought and Leadership, so thank you for coming out for our first event of the academic year. Before Professor O'Malley, Deborah O'Malley, introduces our speaker, I did want to say a few words about the Institute. The Ohio General Assembly founded the Institute in the summer of 2023. Our purpose is to sustain teaching, scholarship, and public programs like this concerning the principles and core texts of the American political order and the greater Western tradition. In connection with our core mission of providing education in American constitutionalism, we are engaged in forming the future leaders of America and by mentoring them in the skills they need to navigate challenges of discourse and debate in the public square, as well as in business and academia. This year, we're offering our first undergraduate courses on topics ranging from statesmanship to civic discourse. Next semester, we'll be offering specialized courses in rhetoric, the history of American conservatism, and competing theories of justice. We'll also have a unique course in which students study and then model historical U.S. Senate debates. Sign-up sheets are available in the back of the room, so you can receive information about each of those courses and scholarships, but there's also a general sign-up sheet available if you just want to keep up with our public programs and events. Additionally, our website has information about our certificate program and our past events and future events that we'll be having. Please also feel free to come and speak with me and the Institute faculty after the lecture. We'd love to hear from you. Let me now invite Professor Deborah O'Malley to come forward and introduce our speaker.
It is my pleasure to introduce my friend and former boss, Vincent Phillip Muñoz. Professor Muñoz is the Tocqueville Professor of Political Science and a concurrent professor of law at the University of Notre Dame. He is founding director of Notre Dame's Center for Citizenship and Constitutional Government, which serves as a model for our very own Constitutional Studies Institute here. Professor Muñoz writes and teaches about constitutional law, American politics, and political philosophy with a focus on religious liberty and the American founding. He is the author of numerous books and academic articles, including his most recent book, Religious Liberty and the American Founding, Natural Rights and the Original Meanings of the First Amendment Religion Clauses. His scholarship has been cited multiple times by the United States Supreme Court in various church-state opinions, by Justice Alito in Fulton versus City of Philadelphia, and by both Chief Justice Roberts and Justice Thomas in Espinoza versus Montana. An award-winning teacher and a popular lecturer, Dr. Muñoz has spoken at nearly 100 colleges and universities just in the past several years. He received his BA at Claremont McKenna College, his MA at Boston College, and his Ph.D. at Claremont Graduate School. Please join me in welcoming Phillip Muñoz.
It's really a pleasure for me to be here. Thank you very much. Especially to be one of the first speakers of the Institute for American Constitutional Thought and Leadership. Let me thank Mike Gonzalez for the invitation. Now, the real reason I'm here, I have to confess, is you stole Debbie O'Malley from us at Notre Dame. She's an especially popular teacher and an especially effective administrator, so I'm actually coming here to steal her back, and going to put her in my carry-on luggage. It was painful, but a wonderful hire for you. So congratulations. If I had my way, I would steal her back. Okay, our time is short, so let me get right to it. I'd like to start with two recent Supreme Court cases. The first one was decided in 2022, so just 2 years ago. It involved a public high school football coach. His name was Joseph Kennedy. Starting when he first was employed in 2008, Coach Kennedy took a knee in prayer after his team's high school football games. He would go to the 50-yard lines and kneel down in prayer. In 2015, so several years later, his school district found out about it, and the district informed Coach Kennedy that he needed to stop his prayer practice, or at least not pray in the sight of students. Coach Kennedy did not much like the demands of the school district, and when the case got up to the Supreme Court, there were some factual disputes, but the end result of the dispute was Coach Kennedy refused to stop praying. his contract was renewed, and he was effectively terminated from his position as a result of his prayer practice. The coach sued, wound up before the Supreme Court. The court made its decision again in 2022 in a case called Kennedy versus Bremerton School District. Okay, a second case. This one you probably remember. In 2018, the Supreme Court heard a case brought to it by Mr. Jack Phillips. Phillips, you might recall, calls himself a cake artist. He designs custom wedding cakes. Now, this is because of my own ignorance. I had no idea how much a custom wedding cake can cost. These are cakes in the thousands, if not tens of thousands of dollars, believe it or not. Two gentlemen walked into a shop one day called Masterpiece Cake Shop, Charlie Craig and Dave Mullins, and they wanted to procure Mr. Phillips' services to design them a cake for their same-sex wedding ceremony. Phillips informed him that he would sell them a cake off the shelf, but he wouldn't be willing to design them a custom wedding cake on account of his Christian religious beliefs. Craig and Mullins then filed a discrimination complaint. The Colorado Civil Rights Division found that Mr. Phillips and his cake shop violated Colorado's Anti-Discrimination Act, which prohibits in places of public accommodation discrimination against same-sex couples. The enforcement agency ordered Mr. Phillips to change his business practices. Mr. Phillips sued. His case, too, wound up before the Supreme Court, Masterpiece Cake Shop versus Colorado Civil Rights Commission. These two cases, Kennedy and Masterpiece Cake Shop, are noteworthy insofar as they made it to the Supreme Court, but they're also typical insofar as they exemplify the core divisions in America regarding religious freedom and the Constitution. To speak in very broad terms, the progressive left emphasizes freedom from religion, especially freedom from the influence of traditional religious beliefs about sexual morality. Leading progressives contend that Coach Kennedy should be prohibited from praying in front of his students, lest his students feel coerced to pray with him. When state officials endorse religion, especially in the context of a public school, they argue that psychologically pressures students to pray, unjustly encroaching on the liberal conception of individual moral autonomy. To preserve autonomy, progressives contend that we must overcome long-standing forms of oppression, including religious condemnation of homosexuality. So, whereas public school kids must be prohibited from unwanted prayers, the market must be protected from unwanted discrimination or invidious discrimination. So the right to be free from religion means Coach Kennedy should not pray in front of his students as a high school, public school employee, and Mr. Phillips must be made to design the cake. Social conservatives, by contrast, say religious freedom is freedom for religion, especially the liberty to live out one's religious beliefs in the public square. So religious liberty, most conservatives would say, means Coach Kennedy has a right to kneel in prayer, even as a public school teacher, and Mr. Phillips has a right not to bake the cake. Given these seemingly contradictory commitments, freedom from religion on the one hand, freedom for religion on the other, what are we to make of our first freedom? And what, if anything, might the founders have to teach us? Does the founders' understanding of the Constitution, the original meaning of the Constitution, mean freedom for religion or freedom from religion? Does it even offer a coherent understanding of religious liberty, something that we might learn from or borrow from today? That's what I'm going to address in this lecture. My argument is going to be that the founders have much to teach us, but the lessons they offer do not fall neatly into current contemporary political categories. Freedom from religion, on the one hand, and freedom for religion, on the other, are both aspects of the founders' understanding of our inalienable right of religious liberty. That's their language. But the freedom our founders secured for us constitutionally was far more limited and far more democratic than either contemporary progressives or contemporary conservatives admit. What I'm going to argue this afternoon is that the founders had a robust but quite limited understanding of the constitutional right of religious freedom. The essence of my argument is that the founders conceived religious liberty in jurisdictional terms, jurisdictional limits on state power. The founders believed that there were a few things that government could never do vis-a-vis religion, but when it acted within its own sphere of competence, that when government acted within its own legitimate sphere of authority to advance the common good or the public good, as the founders would say, religion and religious individuals both could be benefited and encroached upon in their self-understanding. Religious citizens could be benefited by the law, but also disadvantaged by the law. That is because the founders' understanding of religious freedom was much more limited than either the left or right would admit today. Okay, so this is what we're going to try to do, and I'm going to try to do this relatively quickly so we have lots of time for discussion. I'll start with the founders' understanding. Again, I'm speaking in very broad and general terms, asserting a number of conclusions without accurately or adequately documenting them. Please ask if you want more argumentation on any particular point. Start with the founders, go to the modern Supreme Court, and then go to some contemporary church-state disputes, try to explain how the founders might address them. When I do this in class, what I'm about to do, and I'm going to try to do in 30 minutes, takes me about 3 weeks. So I'm going to move quickly, but hopefully still in a way that's understandable. Okay. I think we don't quite understand the founders, both on the left and the right, because we've forgotten their basic principles of government. The founders, like us today, used the language of rights, but their understanding of rights, I think, is actually far more nuanced and interesting, far philosophically richer than our typical understanding today. We tend to think of rights as interests, things that are important or especially necessary for us. Just to take one example, we think healthcare is a right because bodily health is so important. At the same time, we recognize that our rights must be limited because there's lots of competing rights. So fundamental rights can be curtailed, to use, since we're in a law school, when compelling state interests are advanced and the least restricted means are used. The underlying premise on how we think about rights today, I think, is that rights come from the state. We think good government provides extensive rights because we think the role of government is to provide for us. But at the same time, we understand rights must be limited. So the extent to which any particular right is available to us depends on it being balanced against other rights and other state interests. A process that is done largely by the administrative state, but supervised by the judiciary, by lawyers. Okay. The founders, I think, had a different conception of rights, at least when they spoke about natural rights. Natural in this context means that the foundation of our rights lies in human nature. Human nature, we're endowed by the Creator. Natural right to religious liberty, in other words, is not granted by government. It's part of the moral fabric of the created moral order, an order in which rights and duties are reciprocal. A just government recognizes this pre-existing moral order. It does not create it. The founders held that our natural rights, again, are endowed by our Creator, not granted by the state. The founders also held that our rights were not opposed to our duties. I think a notion we tend to lose, both on the left and the right. It's not a partisan position. I just think it's a modern position. In fact, our duty to God is why James Madison says we have a right among men. What is here a right towards men, Madison says, is a duty to the Creator. It's the duty of every man to render to the Creator such homage and such only as he believes is acceptable to him. Okay. The political institutions we create and the civic obligations we impose accordingly must recognize these pre-existing sacred duties in the minds of the founders. Our politics remains limited out of respect and deference to the higher claims of religious authority. We have a political right to religious liberty, again, because we have more sacred and sovereign duties to God. For the founders, then, the rights of religious liberty impose limits on state authority. The First Amendment says Congress shall make no law prohibiting the free exercise of religion. Because political authorities cannot legitimately exercise direct authority over religious exercises as such. Congress and the states with incorporation lacks any legitimate authority to regulate religious worship as such. The state cannot determine how we worship, when we worship, where we worship, as worship, or even if we do worship. This is how the free exercise of religion protects those who do not believe and do not worship. Atheists are as protected as religious people by the First Amendment. Government officials have no authority to punish worship or the lack thereof. Government can't punish religious worship because we don't give it authority to do so. That's what it means for the people to retain an inalienable right. This absence of governmental authority to regulate worship is also why the founders said that the state cannot establish a religion. The Establishment Clause and the Free Exercise Clause together articulate limits on governmental authority. Limits that are meant to protect the non-alienated or inalienable right of religious liberty. So just as government cannot regulate religious practices, it cannot legitimately license religious ministers. Licensing is a very good example of when government has authority. I mean, most of the people in this room, or many of the people at least, either have or will get a license from the state. If you want to practice law, we're in a law school, you have to have a law license. If you want to practice medicine, you have to get a medical license. If you want to cut hair, you have to have a cosmetology license, right? I mean, the only thing you don't really need a license to, is to be a college professor. Like anyone can be a college professor in the eyes of the state. Think about minister licenses. Can the government, to say, if you want to preach the word or preach the gospel, do you have to get a license from the state? Why don't we have minister licenses? And the answer is because government doesn't have authority to say who is or who is not a minister. Why doesn't government have that authority? Because we, the people, never gave it that authority. The founders understood these limitations on governmental authority to be categorical, which is why they declared in the First Amendment, Congress shall make no law. No law for the founders, unlike the modern court, means no law. Since government lacks authority to regulate religious exercises, for example, to license ministers, it can never legitimately do so, even if there's a compelling state interest accomplished in the least restrictive means. That's what I mean by the founders' approach is very different from modern jurisprudence. But here's the punchline. The categorical character of religious liberty means that its scope, the scope of its constitutional protection is very narrow. When government acts within its proper domain, religious citizens can be accommodated from burdensome laws, but they have no right to be exempt from burdensome laws. Likewise, if government cooperates with religion to accomplish an otherwise civic end, no constitutional barrier is trespassed. The founders understood the inalienable natural right to religious liberty to require only the state remain within its legitimate sphere of authority. So legislation can both impact religion in ways that religious individuals think benefits them, but also frustrate religious citizens in ways that they find objectionable. Sorry, I'm a little bit behind here. So my students tell me that visual cues help them. So this is my very poor attempt to draw out what I just talked about. Alienated rights is where, so the founders distinguished, there's two types of natural rights. Rights we alienate and rights that are inalienable. To alienate a right doesn't mean to lose it. It means to turn it over to the government for protection. Right to property is an alienable natural right. Right? The sphere of government is in the larger circle, but what remains outside of government is the left circle. If that seems confusing, think about another example of an inalienable natural right is the right to revolution. It makes no sense to say you're going to get a revolution license from the government. If you understand what revolution is, you understand by nature it's an inalienable right. Does that make sense? Okay. Let me turn to the Supreme Court now. Whereas the founders' approach focuses on jurisdictional boundaries, marking clearly where the state has authority and where it does not have authority. The modern court has taken a more managerial role. Rather than enforcing the Constitutional's fixed lines or fixed limitations, the modern court has sought to achieve particular results. This is true on both left and the right. The modern court has not been an umpire, but rather a player in the game. Let me start with the left, but I think it's true both on the left and the right. The results the court seeks to achieve depends really on who controls the court. So when court progressives dominated the court, starting in the 1940s and really through Justice O'Connor's tenure on the court in 2005, they built the wall of separation between church and state. They read the Establishment Clause to prohibit government policies from advancing religion, even if those policies pursued an otherwise valid secular purpose. The leading case here is Lemon versus Kurtzman. I mean, this is, maybe I'll just take a minute. It's an interesting case. It's 1970s, and it involved a Rhode Island statute that funded math teachers in in private schools, but overwhelmingly Catholic schools. And the context here is really interesting. So, I mean, why were Catholic schools so good in the 1950s and early 60s? And there's a structural reason. I mean, who's teaching in these Catholic schools? I mean, who's teaching in them? Religious sisters, right? And what do these religious sisters make? What's their salary? Almost nothing. So you have an extraordinarily talented workforce. I mean, these women are amazing. And they're getting paid almost nothing. It's like an administrator's dream. And this is why, in part, why the schools were so good. But what happens to the Catholic Church in the 60s? Well, lots of priests and religious leave, right? And so if you're running a Catholic school, your extraordinarily talented workforce, which would cost you almost nothing, has left, or many of them have left. And so what do? Well, you hire new teachers, but you have to pay them because, they have families to support. And so this provokes a crisis in Catholic education. And so some states, like Rhode Island, they pass legislation saying, look, our private schools in the state are really suffering, and they provide a public service. They teach kids all sorts of things, religion, but math and things that the state is interested in. So Rhode Island passes a Salary Supplement Act. And the details are the essential details are, if you teach math or what we call STEM today in a private school, again, private schools are almost overwhelmingly Catholic. If you teach STEM classes, the state, and you use the same textbooks that the public schools use, will give your teachers a salary supplement that will bring them up to the level or within 15% of what the public school teachers make. They can't make more than the public school teachers, but they can be brought up to be within 15%. Because people around want the kids in private schools to get educated in STEM as well. The Supreme Court strikes that down as a violation of the wall of separation, because taxpayer dollars might end up advancing religion. And the wall of separation means the state can't advance religion. Why can't it advance religion? Because that encroaches upon the liberal conception of autonomy. Okay? We see this today really in Justice Sotomayor. She's the leading separationist today. Now she's in a minority position. Recent case, Missouri. I'm trying to remember the state. Missouri had a program, an environmental program for scrapping used tires. I just put two new tires on my car. What happens to the old tires? What do you do with them? Well, you can't just burn them. You don't want to just throw them away. So one of the things they do now, they grind them up, and they use the small black grinds for playgrounds. The soft surface that you see on playgrounds. I mean, when I grew up, it was rocks, but now they have, the soft surface. And on AstroTurf fields, those are used tires. So Missouri started this program a scrap tire program, where if you had a playground, you could apply to the state for a grant to get your playground resurfaced for these used tires. So the real purpose is environmental, but also to protect the safety of children. And so this school, Trinity Lutheran school, they have a playground, and they apply to participate in this program to get their playground resurfaced. And Justice Sotomayor on the court, representing the old liberal position, said, no, Trinity Lutheran must be excluded from the program, because to let them receive taxpayer dollars could advance religion, and the Constitution prohibits that. So that's the progressive approach. Okay, what about the conservative approach? And let me try to go a little bit more quickly here. Sorry, catching up here. Okay. I've talked about the Establishment Clause. Let me talk a little bit about the Free Exercise Clause. In a 1963 case called Sherbert versus Werner, the court held, and this was originally a liberal position, but is now the conservative position. The court declared that religious free exercise in the First Amendment means that religious individuals have a constitutional right, a presumptive right, to be exempt from laws that they find burdensome. Now, this has been overturned formally in a case called Employment Division versus Smith in 1990, but effectively, Employment Division versus Smith has been curtailed by the conservative Supreme Court. And in 2021, in a case called City of Philadelphia versus Fulton, Justice Alito, the leading originalist, arguably, has called for return to Sherbert. What is Sherbert? Let me give you an example of a case. Famous case, Wisconsin v. Yoder. Wisconsin in the 70s had a mandatory school attendance policy. Like, you had to go to school. It could be a private school or a public school, but you had to go to school. This burdened the Amish. In Wisconsin, you had to go to school until you turned 16. The Amish usually withdraw their kids after the 8th grade from public school, from all schooling, so when they're 13 or 14. So the Amish did this, they withdrew their kids, and the superintendent of public schools started fining Amish parents every day their kids were not in school. So the Amish filed a lawsuit, and they said, look, the First Amendment protects the free exercise of religion. Withdrawing our children from formal schooling after 8th grade is an exercise of our religion. In fact, we see it as central to preserving our religious community. So we deserve an exemption from this law. In fact, we have a constitutional right to an exemption from this law. The Amish didn't say the law was invalid for other people, just as invalid as applied to them, because of how it burdened their particular religious practice. Everyone follow? The court voted in favor of the Amish in a case called Wisconsin v. Yoder. That's what I call the exemption approach to the Free Exercise Clause. Right? So religious people have a constitutional right to an exemption from a law that they find burdensome, subject to strict scrutiny. But that's the conservative understanding of the Free Exercise Clause. It's a right of exemption. Whether it's to build the wall of separation or to carve out exemptions for religious believers from otherwise valid laws, both liberal and conservative justices would interpret religious liberty to require special treatment for religious citizens. Special treatment ultimately administered by the judiciary, often in a case-by-case basis, and often using relatively vague standards. This managerial approach allows jurisprudential progressives to keep the public square free from religion when they deem it necessary and they're in control, and it allows judicial conservatives to grant exemptions to religious citizens from laws that they find disagreeable, at least in their application to religious citizens. I probably shouldn't say this in a law school, but what is a compelling state interest? Or what is the least restrictive means? It's whatever the court says it is. So it effectively allows courts to exercise a veto over legislation. And in this case, the conservative case, exempting religious citizens whenever they have five votes to do so. Okay. The result of this modern jurisprudence is that religious liberty is no longer treated as an inalienable natural right that limits the scope of the state, but rather as an attribute that earns one's special disabilities or privileges from the state. Rather than limiting the state's authority, the state takes authority over religion and uses it to dole out special treatment, either to benefit or to harm. Following the founders, I think, following their natural rights political philosophy would lead to a very different approach to constitutional law, to First Amendment law. It would not lead to the wall of separation, nor would it lead to religious exemptions from burdensome laws. It would rather be much more limited. A jurisprudence consistent with our founding philosophy would prohibit government from exercising jurisdiction over religious exercises as religious exercises. And it would impose a categorical rule that government cannot regulate religion as religion. Here I'm drawing a distinction between direct burdens and indirect burdens, okay? So government can have building regulations at which a house of worship would fall under, but government can't tell the church where to place the altar. That's the difference. For the Establishment Clause, this natural rights approach would prohibit the state from acting like a church or from delegating authority to churches. State actors could not write prayers for students, could not appoint bishops, could not make rules for who can or cannot be a member of the clergy. The state cannot have tenets of official religion. These are all examples that come from the founding era of what an establishment was. The state also could not delegate its authority to churches. This is what we talk about, taxpayer funding of religion, and was that an establishment? That's all misunderstood, misframed. What an establishment of religion was, I mean, you have to understand how churches worked at the time of the founding. If you joined a church, you join voluntarily, but once you join, you get a pew assessment. That is, the church imposes a contribution on you. It's not like today where you decide how much you're going to contribute, like me. I'm Catholic, and it's just the annual bishop's appeal, and, so I protest by not contributing to it. Back in the day, is the church imposed a pew assessment on you, and if you didn't pay it, the church had the authority of the state to collect it. That is, the state delegated its taxing authority to churches. That's an establishment of religion. It's the delegation of state power to churches in financial areas. Under the founders' approach, if government policy pursues a valid civic purpose, and if religious individuals or institutions qualify to participate on that program, irregardless of their religious character, they can participate. The founders' approach, unlike the modern liberal Supreme Court approach, would not read the Establishment Clause to mandate disfavorable treatment or even discrimination against religion. If the state has a program to fund math teachers, to help alcoholics, or to do whatever, churches and religious people can participate. The same equality before the law principle would apply to the Free Exercise Clause. Following the founders would only mean that government could not punish or prohibit or command religious exercises. Not that the government must exempt religious citizens from laws that they find burdensome. Now, I want to be clear here. The founders recognized that the rule of law is not perfect, and that in some circumstances, exemptions might be necessary, but these were legislatively given, and there was no right to such an exemption. It was discretionary treatment up to the people through their representatives. So there's no right for the Quakers not to serve, Quakers are pacifist, no right for the Quakers not to be drafted. But if the people through the representatives determine that we're not going to make Quakers fight, or they can do something else, or that Quakers are lousy soldiers, they can exempt Quakers. But a legislative exemption is far different than a constitutional right. There's no constitutional right to exemptions under the Free Exercise Clause in the founders' political philosophy. Okay. This natural rights approach that I've only sketched, and I'm drawing this from my new book, which goes on and on to explain and defend this. This natural rights approach draws relatively clear lines concerning religious worship and state power. It would have the judiciary police these lines. The judicial question would always be, does the state have authority to act in this way? Not, is the legislature or the executive using the powers that they do have in ways that judges don't think is fair? Okay. All right, let me start to draw to a conclusion here. I think church-state issues remain in the forefront of our culture wars, in part because it's easy to see, at least from my opinion, the unfairness of each side's position. Court liberals seek to prevent religious individuals from participating in our civic life on equal terms. They tend to unjustly penalize religious citizens to advance an exaggerated notion of freedom from religion. Court conservatives seek to exempt religious individuals from the civic obligation to follow the law, to follow duly enacted law. They privilege religious citizens to advance an exaggerated notion of freedom for religion. Adopting the founders' approach would not please everyone. In fact, it probably pleased no one. Those on the left would have to accept that freedom from religion only means that one cannot be coerced to pray, or to go to church, or to participate in worship. It does not mean that religion cannot be present in the public square. Conservatives would have to accept that religious freedom only means that government cannot impose targeted disabilities on religion, not that one is entitled to an exemption from an otherwise valid laws. This more modest approach, as I said, would probably satisfy no one. It certainly would not satisfy lawyers who exercise more authority in society under the court's current approaches, whether left or right. If we followed the founders' approach, religious and non-religious citizens would have to learn to get along better. They'd have to attempt to work together to adopt laws that injustice must be applied to everyone equally. Social conservatives would have to focus on preventing laws that they find oppressive, not on getting exemptions from them. As I said, this might only inflame political disputes, but it seems to me our current approach hasn't lessened them. In fact, our debates over church and state are inflamed because we don't have a democratic process of compromise to deal with them. Okay, what about those two cases I started with? If we followed the founders, Jack Phillips, the cake artist, would not have or receive a constitutional exemption from Colorado's non-discrimination law. If the people of Colorado decide, look, if you want to do business in our state, you have to serve everyone, then if you open a business in that state, you have to serve everyone. If Mr. Phillips or other similar people don't want that law to be in existence, they would have to work to change the law, not plead for a special exemption from it. Now, it's interesting to think about how might Mr. Phillips do this. Well, perhaps he would reach out to other small business owners, including progressive business owners, and say, just as you might not want to have to print a t-shirt, for example, for my church, if you disagree with my church's message, I shouldn't have to make a cake for the wedding I don't want to do. But those are legislative arguments, right? And if we went through this process, I think we'd see people similarly situated, small business owners in this case, but with very different politics, try to find common ground. But we don't do that type of politics, which happens among citizens, because we kick everything up to lawyers. We preempt democratic negotiation. I actually think that inflames political disagreement. It doesn't help resolve it. So if religious citizens think that laws would be oppressive when applied against them, they would have to be more political and less legalistic. They'd have to persuade their fellow citizens why such laws are bad. Okay. What about Joe Kennedy, the coach who prayed after football games? If a school district does not restrict expressive behavior by its employees, by its coaches after football games, you can't single out religious behavior and say you can't do that. And no school has regulations about its coaches' expressive behavior. It's conceivable that a school district might adopt such a policy, and if it did, it would apply it to everyone equally, right? But think about if Coach Kennedy took a knee at some other time during the game, during the Pledge of Allegiance or the Star-Spangled Banner. You can't punish him for taking a knee in prayer and not punish him for taking a knee for other reasons. Free exercise clause prohibits that. Free speech would prohibit that as well. For the founders, I think, religious liberty did not primarily mean freedom from religion or freedom for religious individuals to be exempt from otherwise valid laws, at least not in the way that the modern Supreme Court has interpreted freedom for religion or freedom from religion. Religious liberty for the founders meant that individuals of any religion and all religion could be American citizens. And that includes those with no religion at all. Religious freedom meant that all religious citizens and non-religious citizens would be treated alike and equal under the law. It also meant that government could not target or regulate religious exercises as religious exercises. This is the primary understanding of religious liberty, which limits the authority of the state. Okay, my main purpose, I hope I've done so with enough time for a discussion, is to explain the founders' natural rights political philosophy. As you've probably tell, I find much compelling in it. But really, understanding the founders is only step one. We understand the founders because they're interesting and different from us today. They provide material for us to argue. Whether we adopt the founders or not depends on both prudential and legal considerations about our current state of contemporary American and political legal culture. But we can't have that debate on whether to follow the founders unless we first understand them. And that's what I hope I've conveyed to you today. Thank you very much.
So in your presentation of the founders' understanding, was there concern ultimately to assist religion? Like, do they perceive it as something higher that ultimately, all right, we're not here to promote or harm it legally. However, at the end of the day, we want it to be healthy and be facilitated. That I think you see in some of the founders, at least some of the arguments they make. Or is there more of an intent to contain it, to contain dangerous tendencies that they might see based on the wars of religion, or maybe a bit of both? But ultimately, if the founders' understanding as you presented it, do you see it more as inclined towards the promotion of healthy religious life within the polity, or to contain, or possibly going either way, depending on the founder?
Yeah, very good. That's a nice question. And I eliminated some things that address this just because I want to make sure I got through and left time for questions. So I appreciate the question. We tend, both conservatives and liberals appeal to neutrality today. You could say, if you ask me, well, what's the doctrine that both sides agree to? They'd both say the state should be neutral towards religion. I think that's actually a mistake. The state's not supposed to be neutral towards religion. The state is supposed to be in favor of religious liberty. Right? The purpose of the state is to secure liberty, not to be neutral. Now, you secure liberty, religious liberty, by limiting the state. Right? So the aim of the state is not to get you to heaven or to tell you what to believe about God. It's to leave you alone so you make up those decisions on your own and in your church community. We limit the state in part to respect the rightful authorities of churches. Right? So the founders, if that Madison quote, we have a right among men because we have a duty to the Creator. So proper religious worship is the end, but proper religious worship must be free. So in one sense, you could say it's pro-religion, right? But it's pro-religion only in the sense that, in the sense that having licensing marriage is pro-marriage. We're facilitating the opportunity for people to get married. But we do it differently with religion. We're facilitating the opportunity for people to pursue the truth as they understand it by getting the state out of the way. That was the founders' understanding.
Regarding Kennedy and Bremerton School District, if Kennedy had organized a dance at the 50-yard line and Bremerton didn't renew his contract because they didn't like that, can you tell me how is that different from them not liking him having a prayer on the 50-yard line?
Well, I'm trying to think what this dance might be. But let's say but it's interesting. It's an interesting, let's say it's a sexually suggestive dance, which he engaged with cheerleaders on the team. And we say, look, is that, right? Does the state have competence to protect the health, wealth, and morals of the student body? And the answer is yes, right? But there the regulation or the penalty, as the firing, would be connected to his role as an educator, right? Now, he can't direct the students to pray. That's for certain, right? He can't tell the guys on the team, you must pray, right? So he can't write a prayer for them. right? So, and we have cases on this, the Engel versus Vitale, the case from the 60s. So this is the Regent's Prayer case. And this would be what's prohibited. In 1960, well, before 1962, in the New York public schools, the school day started with a prayer. And it's completely innocuous. It's, we pray for the protection of our country and our teachers, or something like that. But it's a prayer. And school authorities have no authority to write a prayer for the teachers and students. So he can't coerce kids to pray for certain, right? The difference between the dance and the religious activity, they are punishing him for praying. It's illegitimate for the state to punish someone for praying. It's not illegitimate to punish an adult for doing sexually suggestive things with a student. So I changed your hypothetical, but I think that's how you'd reason through it.
So suppose Jack Phillips here's your lecture, which was wonderful, and he says, look, I would love to change the law. I would love to work with people to change the law. It's never going to happen in Colorado. And so I'm going to ask for an exemption as a kind of second best. We shouldn't have the law, but exemptions are ways of saying, well, okay, we got something. We got some kind of auxiliary compensation or something. Is the problem there that constitutes unequal treatment? That's the response to him, even if he has no prospects of changing the law whatsoever.
Yeah. Well, the first, I mean, you could say that actually is a problem for the equal protection of the laws. You're treating individuals differently on account of their religious character, right? And that actually is a constitutional problem. And you can illustrate that by thinking through, okay, if we're going to give Jack Phillips an exemption, there's all sorts of decisions that the state must make. The first decision is Jack Phillips authentically religious? Now, there's one of two ways you can say, well, he says he is, so he is. But of course, that means anyone could say they're religious. Well, you can't give an exemption to anyone and everyone from every law. So you have to go back. Is Jack Phillips authentically religious? Is this a real religious burden to him? That is, a state official is making a judgment about what is authentically religious or not. That is what the Constitution was meant to prohibit. That is what I mean by the state taking jurisdiction over religion. A state official saying you are sufficiently religious or you are not sufficiently religious is why we had, in part, the American Revolution, to prohibit state officials from doing that. So the very act of exemption grants authority that was not given.
So for the founders, the courts wouldn't be in the business of judging sincerity?
You could judge sincerity, but you're still going to have to say, look, I sincerely believe that I cannot work on Saturdays. At Notre Dame, we have two holy days. We have Sunday in the Basilica and Saturday in the football stadium. So one approach to this is, well, we'll just have a sociological definition of religion. If you follow that out, if it looks like a religion, acts like a religion, it is a religion for constitutional purposes. I mean, if you go to Columbus, Saturday looks like a day of worship. To a false god, I might add, but. And so you're going to have to start making judgments on, no, worshiping Ohio State football is not a religion for legal purposes. Being a Seventh-day Adventist is. But that involves the state making judgments on what is authentically religious or not. And that has real constitutional problems. So let's go back. I mean, the reason I picked the Yoder case, the Amish case, is usually I get this question like, why are you so mean to the Amish? Why don't you like the Amish? No one wants to make the Amish go to school. Like, why do you hate the Amish so much? If you read the court record, it's very interesting. The Supreme Court evaluates, and they evaluate the Amish religion, and they're like, yeah, the Amish do a good job. Like, their religion is good, and therefore they should get an exemption. And I agree that the Amish religion is good and they should get, I have nothing against the Amish. But the availability of an exemption was made because a Supreme Court judge evaluated the religion and found it favorable. That act is deeply problematic. And because we like the Amish, we're not worried about it. But empowering state officials to make judgments about your religion is a very dangerous precedent to follow. Now let me push it even further. Let's say the Amish lost. I would say the Amish should have lost. What would have happened? Well, maybe they just would have found Wisconsin a burdensome place to live. Undoubtedly they would have. So maybe they would have advocated with other people or found other people in the state that said, hey, do you have reasons not to send your kids to school too? Because you know what else was illegal in Wisconsin in 1971? Homeschooling. You could not legally homeschool. And perhaps the example of the Amish, and here's what would have happened. The Amish still would not have sent their kids to school, and they would have been fined. And if they did not pay their fines, they would have been sent to jail. And do you think an Amish parent going to jail because they just want to live their religion would have made the local news? Would have caught the attention of state legislators? Perhaps would have said, hey, do we have to make kids go to school? Is it reasonable not for the Amish? If it's reasonable for the Amish not to send their kids to school, might it be reasonable for other people not to send their kids to school? That you can educate your children in all sorts of different ways? That conversation was preempted by the Amish getting an exemption. What was really preempted was the people governing themselves, and not us being governed by lawyers. Now I know that's a risky thing to say here in a law school, but that's really what exemptions do. They take away the people's right to govern themselves and they turn it over to lawyers. It's a sort of aristocracy. That's why I say the founders' approach is much more democratic. Again, I realize I'm in the belly of the House of Lords, so
Doesn't this sort of model of religion presuppose like a sort of universalism or almost a liberal conception of religion in which it's sort of taken as, community activities instead of something that encourages people to act in ways that they might not do before, or to actively spread their religion to like everyone else in ways that might be forceful? Isn't it sort of assuming that these presuppositions, such as the sanctity of life, are kind of taken for granted if, in the case of abortion, that they're sort of ignored? Isn't there a sort of central conflict there that's inescapable?
No, I'm not quite sure I understood the tie to abortion, but the general thesis of your question, I think, was very well taken and very perceptive. Tell me your name? Marcos. Marcos. It's a very, very good question. And Marcos' question, at least as I understood it, look, this whole approach seems to have an implicit understanding of religion animating it. And I think that's right. It presupposes that religion to be true must be practiced, we'd say today, must be practiced authentically. That in James Madison's word, that religion is a matter of conscience and conviction. That true religious worship is something given freely, according to your conscience and your convictions. So it presupposes a number of different things. There's all sorts of theological implications. I mean, Carlos, your question is very good. It presupposes that what is most central to religion is interior belief, that is, conscience and conviction, not simply a behavior. It presupposes that salvation is individual. I mean, this is the example I use in my class. I say to the Notre Dame students, I usually say this on like a Thursday before a game day weekend, just like today. Imagine that God punished dormitories as a whole. Like either your whole dorm is condemned or rewarded. Would you be more concerned with your dorm mate's behavior? You'd be a lot more concerned. The presumption that our souls, if I can use that term, are individual, and we're judged as individuals, is an enormous presumption that animates the entire natural rights approach. Not to mention that nature is to be taken seriously. And so we could go on and on, but your underlying intuition that there is a certain understanding of the moral order. Now, let me say one more thing on this. It's not, Madison's position in particular it's one of natural theology. He doesn't start with scripture he doesn't actually start with theological assumptions. He starts with what is a human person? And he assumes that we can know something about the moral order, including the divine order, by studying human nature. That sounds very abstract. Let me give you a concrete part of his reasoning. He thinks, okay, what can we know about the Creator if we are made in this way? Well, what is the human being? A human being is, what are the essential attributes of humanity? And he would say reason and free will. Right? So our reasons ought to govern our passion. Right? We can frame it this way. What is the thing you can most give to someone? And the answer is yourself, your devotion, your adoration. And so Madison reasons, a God who created human beings capable of adoring him would settle for nothing less than their full devotion. Full devotion must be given freely. And so Madison reasons, true religion must be given freely. That is, true religion cannot be coerced by the state. And therefore, this is why I said, for a state, and the essence of state power is coercion, for a state to respect religion is to get out of the way. It all follows from human nature, according to Madison. It's an extraordinarily perceptive question.